Hi, I'm Anjali Patel. I'm an estate planning attorney in Arizona, and I help families protect what matters most with smart and simple estate planning strategies. I get asked all the time about how property passes, particularly real estate, after someone dies. So I want to go over a couple different ways that this can happen. One way, if you don't do any sort of planning for your real estate in Arizona, is to look at the deed. If a husband and wife own the property with right of survivorship, then the survivor of the two of them will automatically take full title to the home when the other spouse dies. If the property is only owned by one person, then the property has to go through probate in order for any successor to own the property. If it goes through that process and there's a will that's been validly recorded, signed, witnessed, executed, etc., then if that will lists beneficiaries that are alive, the property will go to those beneficiaries subject to creditors. If my clients don't want to go through that process, there's two simple ways we can avoid it entirely. One is through the use of a beneficiary deed, which is a deed we record through the county recorder's office that specifies if the property is still owned by that owner when they die, it automatically goes to this person. It's got to be an adult, and we don't put extra conditions in this beneficiary deed. And it's not going to work if the property is owned by an LLC. The other way to bypass probate when somebody dies for real estate is to use a trust. This is probably the most common solution that people employ estate planning attorneys to use. And in that case, we can add conditions, we can leave to minor children, and we can name some sort of trustee to manage that property or sell it for the benefit of the children. And so this is a great strategy for families that own any sort of real estate, including their family home, to make sure that that property goes to their kids when they pass away.